we are recording the webinar, so you can come back and watch it again and again and again. I will send the link out as soon as it's posted to our website. And then the other thing is, as far as how to ask questions, you'll just go down to the, if you scroll, sort of hold your mouse and go down to the bottom of your screen, there's a Q&A box there. And I'm just going to ask if you could pretty please put your questions there as opposed to putting them in the chat. It's just easier for us to monitor. And I'll moderate those questions. So if I see the same one coming up and up, you know, and I know that it's not something that is already in Jay's slides, I might interrupt him, but otherwise we're just going to let him flow with it. So with that, let me just quickly introduce Jay. So we knew Jay some time ago. He was Governor Northam's LA for 3 years. He's been on the Virginia Conservation Land Board for 7 years. He's just joined the Soil and Water Conservation Board, just been appointed. And, you know, his understanding of the General Assembly process and the regulatory process is deep and broad. And so I think he's the perfect speaker for today. He's a William and Mary grad, so go Tribe. And he's also got, you know, he runs the Shine and Rise farm out on the Eastern Shore. He was also the Eastern Shore keeper. But if you want to follow Jay on Twitter, it's always an interesting feed because he's got a hashtag dad life, and you get sort of an inside peek at what his kids do on that permaculture farm. So Jay, I'll let you take it away.
Thanks so much, Ann, for having me, and everyone for joining us here in your lunch hour for what is a intensely important conversation around how we create policy and really what the policy continuum is here in the Commonwealth. The work is very important, but it's also sometimes obtuse. And so what we're going to try and do today is break it apart, really focusing on those areas where a law outside of the General Assembly gets put into regulation and really into practice. And so we're going to focus on those areas where you as clean water stewards would have an opportunity to have your voice heard, and really break down some of the main vehicles to get things done in the environmental space. So without further ado, let's jump on in. So I want to just do a brief overview of environmental protection in Virginia. Many of you are familiar with the Department of Environmental Quality. That's the most often, the agency you will interact with the most often if you were doing environmental protection work in Virginia. But it's important to point out that there are many other agencies that also have a foothold in natural resource conservation. Departments like Conservation and Recreation, they're responsible for all of our flood work, and they're responsible for a lot of our soil management here in the Commonwealth, which feeds into water quality and carbon sequestration. And the Marine Resource Commission is in charge of what's going on the water and in our intertidal. So each of these agencies, as well as others, have a role to play in resource protection. And so it's really important that we understand the regulatory framework for each of these agencies. And luckily, as we will discuss later, they have a shared vocabulary and set of rules with some exceptions. So each of these agencies, they're implementing the laws that are passed by the General Assembly, and in some cases, they're exercising authorities that have been delegated from the federal government. So in the case, an example is the Clean Water Act and our VIPDs permits in Virginia. Those are authorized under authority from the EPA. And so it's a combination of authorities that they're acting on. First, let's do an example. We're going to talk a little bit about the water division at DEQ. Obviously, at the Bay Foundation, this is sort of our bread and butter. We spend a lot of time in the water division, and I think it's a perfect example for us to sort of start pulling this process apart. So first, the Virginia Code, state code, includes the State Water Control Law, and this lays out authorities and areas of responsibility for the board and through the board, delegated responsibilities to the Department of Environmental Quality. And this includes big things like our Bay Preservation Act, our Stormwater Management Act, how much you can charge for a permit, sediment control, and many, many other sections. And each of these sections of this code is the result of General Assembly legislation. So the General Assembly passes a law that goes into the Virginia Code under the title State Water Control Law. So Virginia Administrative Code, that's where the rubber meets the road, sort of. And this is where regulations are located. And these are developed by the agencies and the boards. So these include things like the VIPD's permit, water supply planning procedures, boat discharge. And the way to think about the administrative code or regulations is these are the instructions for how a law will be implemented in Virginia. I'd like to say that there's a bright line between legislation that gets passed and regulation, but sometimes there's a gray area between the two. You may end up with legislation that is overly prescriptive or overly vague, and these two aspects are complementary to one another. And while what passes the General Assembly is sort of the idea, the 30,000-foot view and policy objective, the regulation is necessary to meet our water quality objectives or our conservation objectives. And so if you have a strong law, but then you end up with a weak regulation, did you really meet your objective in that legislation? And so the laws that come out of the General Assembly are, in the end, only as good as the regulations that derive from them. And quickly, I just want to note, today when we're talking about boards, I'm speaking about regulatory boards. And those are boards that have specific regulatory authority within the Virginia Code, as opposed to some of the advisory boards. So we'll be talking about the State Water Control Board. They have numerous responsibilities laid out in the state code, and they have enforcement authorities, and they have the ability to approve permits and deny permits and amend them. An advisory board or council is something more like the recently formed Environmental Justice Council. The state has a number of these types of boards as well, but they're really just giving ideas. And a lot of times those ideas go to the General Assembly or they go to the administration, but they don't have force of law behind their decisions. So you want to get something done in the Commonwealth, what are your options? We have many, but what we're really looking at here is sort of a continuum of options that decrease in legal authority as you move down. So as I just said, we've got the Virginia Code and the Administrative Code, and these things really should be in harmony with one another. A legislator gets an idea and says, I want to get this pollutant out of the bay. He goes to get his bill passed, and after it's passed, the agency will develop the regulation for the administrative code that complements that idea and really draws the roadmap for how it comes to be accomplished. So when you're thinking of, you have a plan for resource conservation, the gold standard is passing a law, getting it into regulation. And we'll talk a little bit about regulatory advisory panels and tax in a moment. The sort of next step down on the continuum is creating guidance. Guidance only exists at the agency and the board. There are still some rules for what guidance can and can't be and public comment, but they don't have the same force of law as regulatory, as regulations do. And so oftentimes when you hear someone say we're going to create guidance, many of us in the conservation community may groan because we know that makes it much more difficult to enforce. Budget language. This is ephemeral budget language, and we're going to talk a little bit more about this on the next slide, but it's another way to get at a policy objective that you might have had trouble with in the General Assembly as a standalone law. And the last thing here that worth mentioning are MOUs and interagency agreements. Memorandums of understanding are really, they're better than nothing, but sure, it'd be great if it was a regulation. But sometimes that's where you end up in on the continuum of getting things done from a policy perspective. So first of all, yes, I did do this work part on my own. If I will do commissions, if you need a flow chart with this level of design, but I think it's helpful to just break down really quickly a reminder of what happens in our three branches. So as you all know, we have an executive, a General Assembly, and our judicial branch. We are really going to be focused on this section that says regulation and guidance, and that's boards, commissions, agencies, how those processes play out. But before we move on to that, I wanted to come back to the idea of budget language. This is sort of Hail Mary that has become more and more prevalent in recent years. And this is when you have legislation in the General Assembly, it didn't go as far as you would have liked it to go. Maybe it caught a fiscal impact statement and it didn't look like it was gonna pass. Maybe it caught a cold for some other reason, but those members on the Appropriations, House Appropriations and Senate Finance Committee, they can add language into the budget that may or may not be connected to a line item in the budget. And this is the legislating through the budget. It is generally frowned upon, but it's an option. And our hope for today is to sort of give you a broad overview of all the different ways that things move along. So when this occurs, there's some obvious shortcomings. One is that it didn't really get to go through the committees to give this topic due diligence. The second is that it's ephemeral. We have a 2-year budget in Virginia, so when that budget expires, this language that you may have in there will also expire. A lot of times it's used to sort of put down a marker and say, this is something we want to come back to. It's something we think is important, but we just can't afford it, or we didn't have the time to thoroughly debate it this year. An example from this past General Assembly session is they included language in there to create an interagency task force on environmental justice. This had been a bill that was working its way through, but legislators thought it was going to have a significant fiscal impact statement associated with it. And so rather than have this important idea die, it moved its way into the budget as language, and ultimately the administration sort of eats that cost because there was no appropriation with it. But the work continues. And so that's an idea that the legislature that can come back to at a later date, and they'll have some additional information to make that decision with. So I always say it's a last resort, but it's important to know that that is another way to sort of move the policy ball forward. So before we talk about the General Assembly, we should talk about this man, Iowa Supreme Court Justice Dillon, also known as the Lady Killer. He was a Supreme Court justice in the 1850s, and he is responsible for what's known as the Dillon Rule versus Home Rule. Virginia is a Dillon Rule state, and so that's why in the General Assembly session, you'll see some silly bills like my personal favorite, because I live on the Eastern Shore, is legislation for the town of Waterways to be able to drive golf carts on their streets. Legislation like that is thanks to the Dillon Rule. And essentially what it says is that local governments have limited authority in Virginia. They cannot pass an ordinance. They can only pass ordinances in those areas the General Assembly has granted clear authority. So, put more simply, if the General Assembly has not said something about a topic, the locality does not have the authority to act on it. Plastics and plastic bags in particular were a long-standing example that just recently has been remedied. Arlington for years wanted to take up plastic bags, and for years was prevented from doing so because of the Dillon rule and the inability for the General Assembly to take action. So the outcome, the takeaway here is the General Assembly really is the most important body when it comes to environmental policy in Virginia, because if they haven't said you can do it, you can't. And so it becomes a limiting factor sometimes. So I have promised to say one nice thing about the Dillon rule, and that's that the opposite, home rule, means that you have a patchwork where every single locality may have put a different regulation in place. And so when you think of things like bay restoration, if each locality has the ability to adopt separate regulations, it's very, very hard to have uniformity across the board. And it's really hard to track all of that and potential outcomes. So it makes collective efforts a little more difficult when you have home rule. All right, Virginia General Assembly. I had a chance to look at the registration list, so I know many of you are familiar with the General Assembly. Many of you have had the chance to lobby and or go in and watch a hearing. We have 100 delegates, 40 senators. They meet each winter starting the second Wednesday of January, and you can thank our farmers for that. We, if anyone's ever wondering why the General Assembly meets when it does, it's because there's nothing growing during that time, and the farmers want to get back out in time to plant. So we have a 60-day and a 45-day session that was based on our agrarian roots. They will consider thousands of bills in either 60 days or 45 days. That is a lot of bills. I put considered in quotations because I think the idea that you would read 2,500 bills stretches the imagination. And as a result, there is a lot of efficiencies built into the General Assembly process. And so it behooves you as an advocate to make sure that the legislators are well aware of the idea or your legislation that you're supporting far in advance of the General Assembly session. So they have time to ask questions, to familiarize themselves with it. So I can't stress that enough. If you want to get a bill moving, you need to talk to your legislator about the idea far in advance of session. The pre-file, which is when legislators can put in their ideas for bills to legislative services, that starts the first Monday in December. And it is in your interest that you are pretty close to that date, because it gives you a month, give or take, when you account for the holidays, to talk to legislators and to have a copy of what the bill will originally look like in hand. And that is a huge, huge leg up. Once session has begun, the ability to introduce bills becomes limited, limited until it's completely shut off. And the likelihood of success for an unvetted idea is significantly reduced from something that legislators have had time to digest and talk to all stakeholders about. So, again, if you are looking for a bill, you should start thinking about it right about now in the fall and start building towards having a sponsor for pre-file in early December. Again, because we want to try and cover all bases, you can occasionally talk to a regulatory agency about a bill. Each agency has a policy team. They're tasked with recommending potential bills for whoever the current governor is. And so sometimes those are legislative priority bills, which is the governor says, I want to restore the bay. These are some bills I need each agency policy team to develop for me. And sometimes that's how they get developed. Other times they reflect changes on the federal level or changes on the ground conditions that the agency may identify as a need. And so they'll make some technical recommendations. But for you as an advocate, you can occasionally reach out to the agency if you have a suggestion on a legislative change and sort of put it in their mind for their policy shop to consider. So it's another way to take a bite of the apple. So In September, you all are going to have a wonderful webinar with Ann and with Tanner, and he's going to talk to you all about lobbying for the bill. For today's purposes, we're going to assume we're successful, which I like to think that we're always successful with these bills. So our bill is passed. If the bill passes, it becomes effective July 1 following session unless an emergency clause is included. And the reasons for an emergency clause are that the bill may cause unintended consequences. So say, for example, they pass a bill that says the fees for aquaculture leases are going to go up. And this is an actual example from last year. So all of the fees are going to go up for your for different size leases. The agency and the state, they don't want to run on land to try and get the leases before July 1. So they put an emergency clause on it that said, as soon as it's signed, that is now the law of the land. So we do avoid sort of a land rush in those instances. And there's a lot of other ways you might want to use an emergency clause, but it's mostly to avoid that kind of warping of the market. If the bill does not include regulatory action, it simply moves into the Virginia Code. So this last session, HB 1164 said DEQ, you need to add climate change and DEIJ language to your mission statement. The bill got signed into law, the agency did it, that's it. There's no regulatory action needed. The bill has run its course. If regulation is needed, then the agency begins the process, mostly under the Administrative Process Act. There are some exemptions to this act. There's actually a lot. It's like linguistic Swiss cheese if you take a look at the full Administrative Process Act, but something, the entirety of VMRC is exempt from certain things jump out. It doesn't mean they don't have a process. It just means they're not required to follow the Administrative Process Act. And we're going to talk about two different examples. So the Administrative Process Act, boy, I bet you're excited. You signed up for this webinar right now as you look at this slide. I'm not going to read all of this to you, but essentially the General Assembly created the Administrative Process Act so there would be a set process across all regulatory agencies for how they create regulations and guidance in their respective fields. It was to standardize this process and to, theoretically, to make it more transparent as well. And so what they did is they laid out a couple of steps that you have to do when you're going to create a new regulation. So one of which is you have to issue a notice of intended regulatory action, or a NOIRA, within 120 days of the law's effective date. So most cases, that means within 120 days of July 1 for enactment dates, they will have to issue a NOIRA to let people know there's going to be a new regulatory action. The agency must also provide notice of the planned regulation to the Registrar of Regulations. What that essentially means is they have to say, we plan to write a regulation about topic X. They don't lay out what the regulation is going to be at that point. They just sort of give you an idea that this is coming. And during that time, in response to the NOIRA, you have a public comment period of 30 days. So you can respond to this initial announcement through Virginia, through Town Hall. After that initial public comment period, they can then submit a proposed regulation. And this is sort of the first draft of the document. So that regulation will be posted. That starts another 30-day period. And then they will take all those comments and summarize them, respond to them, and prepare a worksheet for whatever the relevant board is. And all of that goes before the citizen board. In our example today, we're talking about the Water Control Board. So the Water Control Board will get all of these comments summarized, and what the agency's response was to each of the comments. And then the board will have the opportunity to vote yes, send it back for work. They can make minor amendments. If they make significant changes, it may trigger an additional 30-day period if somebody protests. Finally, if the regulation gets support from the board, it goes, the governor has, quote, 30 days to review a final regulation. This is also in quotes because it is not set in stone at all, and there are a number of ways that an administration can delay implementation of a final rule if they decide they want to. So let's look at this visually. Again, this is sort of when you get, we finish up our General Assembly session and you get an email from us, from Peggy, that says, look at all these awesome bills that passed. And we're all like, yeah, we did it. The environment, it was a big winner this year. That's really here at the beginning of our continuum. The GA passes a bill. As I said in the beginning, the bill's only as good as the regulation that comes out of it. So once this bill passes and enactment occurs, that starts the clock on the Administrative Process Act. So from enactment, we have 120 days. You have an opportunity for a 30-day comment period. At the same time, you will often see creation of a RAP, which is known as a Regulatory Advisory Panel. And so this is a group where the agency tries to bring in expertise and stakeholders to weigh in on how proposed regulation should be drafted, how it might, how they can avoid unintended impacts, and hear from both, private entities as well as conservation groups like CBF and JRA and many others that participate in these kinds of RAPs. So these are running concurrently. After the RAP makes a recommendation, the agency's looked at it, and they've reviewed comments from the NOIRA, that's when they'll put out their proposed reg. And this is the first time you have something of substance to really look at and respond to and say, I like this, I don't like this, I think this section needs to go, I think this is going to hurt X, Y, and Z. That's when you can have more of an iterative conversation on what the regulation is going to look like, because they put pen to paper. So after that additional 30-day period, again, we're back before the board. And I have public comment here with an asterisk, because unless you have taken the chance to comment during the 30-day period on the proposed regulation, you're usually not able to speak during the public comment. There are some exceptions where boards have made changes in their individual bylaws. So outcomes at the board, they can adopt, reject, amend. There's some other things they can do, but those are sort of the big three. And as I said, if they make a big enough change, the whole thing will have to go back out for comment. So it's amendments, but within undefined parameters. There's definitely a gray area on what constitutes a significant change. And finally, I have this arrow pointing back, because a lot of times when something comes to the GA to be as a bill, it's the result of work on this continuum that occurred before that General Assembly session. So there may have already been a work group or a study group, either directed through legislation or created through the agency, that has thought about this idea. Then they made a recommendation for a bill, and then a second regulatory technical process begins. And so, that General Assembly time, that 45 days or that 60 days, that's really just one stop-off point in the continuum of public policy that is really just running nonstop, 365 days a year by a lot of excellent employees at our agencies and really committed public citizens who join these boards, which, if we have any members of boards on here right now, thank you. It is the most thankless thing you can do. You don't get paid. You mostly get yelled at. but the work is critically important to water quality, to all resource conservation here in Virginia. So if you ever see someone on one of our boards, water or air or waste or any of the above, please thank them. So Administrative Process Act fun facts. These are particularly the second one I really love. New regulations can be initiated by the agency in response to changing conditions, relevant federal changes, or at the direction of whatever the current administration is. It does not have to be initiated because of a law. That's just one of the ways that regulation can be initiated. The second point, anyone may petition an agency to request the agency to develop a new regulation or amend an existing regulation. And I mean anyone. You can, if you've got an idea and you think that it needs to be in regulation or the regulation needs to be changed, if you can make a good case, they have to consider it. If you have an idea, your petition must explain the substance of the proposed change, and then you must point out some reference to the relevant authority. So effectively, you have to show that the agency has the power to weigh in on whatever your suggestion is. The example here was actually from my backyard, was the question of tomato plasticulture, which is a way of growing. It's the most common way of growing tomatoes now, but essentially you're putting long sheets of plastic on slightly raised mounds. You have no vegetation between the rows. And so during heavy rain events, these plastic sheets sheet the water funnel it onto the soil. And there was massive sediment and nutrient events every time there was a major rain event. And so a gentleman in my community who was concerned about the water quality impacts to aquaculture started this petition process. And when you submit your petition, the agency has to respond to you or give you a reason for a delay within 14 days. And so this began a process to really a conversation between local soil and water conservation districts, DEQ, and the individual, the petitioner. And what they ended up doing was signing a memorandum of understanding to implement some best management practices on these sites. And this success came about because an individual man decided that he wanted to take up this issue. Didn't have to go through a nonprofit, didn't have to pay a lot of money for a law firm. Anyone can pick this up. It's a criminally underused tool to initiate a petition. So let's talk a little bit about some case studies on how these ideas play out on legislation. So the first one here is a bill from 2019. This is SB 1599. This was a bill on groundwater withdrawal and Eastern Shore groundwater management area, essentially trying to incentivize the use of the superficial aquifer in the Eastern Virginia groundwater management area. The graphic here is, if it's confusing you, one, I just like to remind people that the Chesapeake Bay is the result of a giant meteor, and two, that giant meteor has had is really what shaped our groundwater system in the Chesapeake Bay region. And so that's why you're looking at a crater impact. So this bill went through in the 2019 session. Upon enactment, which again, July 1, unless there's an emergency clause, the agency issued a NOIRA, and that created, and also created a regulatory advisory panel. So the first arrow, that's your first opportunity for a public comment period of 30 days if you wanted to weigh in on this. So then the RAP recommendations, they'll go before the State Water Control Board, and there'll be an additional 30-day public comment period, and that'll be once there's a draft of regulations. And again, this, if the State Water Control Board votes yay, the governor will have time, 30 days, to do their review. and the regulation will then go into the administrative code. So that's the process when it's under the APA. As I've noted before, there are some significant exemptions from the APA, Virginia Marine Resource Commission being one of them. So before we talk about a non-APA case study, I just want to circle back on the idea of guidance documents. So again, if you're getting a guidance document instead of a regulation, you're probably disappointed. The guidance document can provide information or guidance of general applicability to the staff or public in interpreting and implementing statutes, agency rules, or regulations. I've heard the agencies refer to it as, this is how we are doing something right now. Guidance documents are very, well, they're not very temporary, but the agency's stance on them is that they are temporary, and that's why they are not being written into regulation. They also do not carry the same force of law. And so when we talk about a guideline, they can become de facto regulation if the agency has not said anything else on the topic, but they don't carry the same weight in court, and they don't carry the same weight in enforcement for that agency as well. They're exempt from most provisions of the APA, but they do still require a 30-day public comment period. An example, which many of you are probably familiar with, is the Chesapeake Bay Preservation Act, which is a guidance document. And because it's a guidance document, it is probably why, it's one of the main reasons that many of you have probably had this frustrating situation where you see somebody clear cutting in the resource protection area right along the water, and you scratch your head and you say, I swear I thought we weren't supposed to do this. Why don't they enforce this better? And the answer in many respects is because it's in the guidance document. And so the agency is limited in its ability to do enforcement for the localities that they've delegated this responsibility to. So the guidance documents are still a way to move a policy objective forward. They're a very important tool in the toolbox for those times when you may not be able to get all stakeholders on board with a regulation, or if the agency is not ready to fully come down on a particular idea. A guidance document it's better than nothing. So you need again, we're on sort of a continuum of how impactful each tool is in your policy toolbox, and guidance documents are somewhere in the middle. They're certainly better than a memorandum of understanding. So a non-APA case study. This one was pertaining to oyster planting grounds. This was also a bill from 2019, SB 1413, and this was brought by Senator Monty Mason. And this is, what's interesting about this is it really highlights how long sometimes it may take an idea to come to fruition. So this bill was a result of a governor's work group that had been convened in 2018. So that work group met for a year. They made some recommendations. I had the pleasure to serve on that. And so we made a number of recommendations, and Senator Mason, as one of the legislative members, agreed to carry the bill with some of them. So a year of work went in on the front end to this idea. Now we're at the General Assembly. During the General Assembly, there was some slight tweaking based on user conflicts around aquaculture leases, but the bill did come out, and it did really three things on the other side that kind of continued that policy conversation. So the first thing it did is it immediately changed application fees. And so that was a change in the Virginia code that as soon as this bill was signed, that was it. Next, it created a non-APA regulatory process. So what that was is they sent Virginia Marine Resource Commission a directive and said, you need to develop a oyster lease renewal or transfer process and fee structure. So that resulted in the creation of a group called the Aquaculture Management Advisory Council, who took on that task, made a recommendation, and even though it did not go through the APA process, it has made its way into the Virginia Administrative Code. The third portion was this initiated the development of a guidance document, and they're developing guidance on submerged aquatic vegetation interactions, as well as sort of amorphous term about beneficial use and renewal guidelines. So you've got one bill that really is culminating in almost 3 years of total work, but we pay a lot of attention to that moment that it's in the General Assembly and say, you know, we did it or we didn't do it. But all of the work that came before that and all of the work that came after is really the nitty gritty to make sure that the bills do what we intended for them to do. So I think we're on time for questions. I'm going to try and look at them myself and hand it over to Anne to ask any we might have.
Yeah, there's one in the chat that I'm going to bring up first, and that is Bill Fleming asked, if one determines or sees an existing regulation needs to be changed, so that's not state code, it's a reg, what is the process of getting the change considered and hopefully adopted? So you spoke to that, but
yeah, but I can unpack it a little more. So what happens is that you can petition for a rulemaking, and you can do this. This is part of the Administrative Process Act. So if an agency is included in the APA, which most of our regulatory bodies are, you may petition them for a rulemaking. And what they ask for in that initial petition is really just two things. One is you need to say, give them a summary of the substance of the change. So if you say, I think we need to tighten this regulation, you would say, I think we want this to say 100 feet instead of 35 feet. And we think that that's really important. Here's why. That's the first part. The second part of the petition is you have to point to their authority to create that regulation or make that change. And that's usually pretty easy. It's certainly helpful if you have an attorney, but I don't, I hate saying you need that to participate in your government. You really don't. If you take the time and look at the state water control law, you'll find that pretty much everything under the sun is mentioned in there. And you can point to that code section and say, I think this is the authority. So those are the two things that you have to give them. At that point, the agency has 14 days to offer an initial response. And that's really whether or not they think your request is substantive or not, and whether or not they think they have that authority. You can appeal that if they turn it down as well directly to the board, but the initial sort of step one is pretty quick. So, 14 days in government time is like light speed. So you're, I think, again, and I really should have put this caveat at the beginning, I'm trying to provide a broad overview of how things usually and or should run. There are 10 million exceptions to the rule, but the way they've written the rulemaking section, the petition for rulemaking, is pretty straightforward. And I think it's something I always sort of stare at and say, I wish more people would take advantage of this. So feel free to write in any other questions you might have on it. Anne?
Yeah, so George, I'm guessing that's George Curran, is saying, is the 120 days after passage plus 30 days before a law goes into effect? In other words, he's trying to figure out
the timeline.
The timeline, yeah.
Yeah, so the 120 days after enactment, that's when the bill becomes effective. So in most cases, July 1. it doesn't have to be a full 120 days. The agency may have a NOIRA ready to go on July 5th. And as long as they issue it within 120 days, they've not violated the Administrative Process Act. So oftentimes it'll come much, much sooner. Once they issue that, there is a 30 days response to the NOIRA. And once they've issued the proposed regulation, there's a 30-day public comment period. So, technically speaking, if an agency was really on its A game, they could, do this in 70 days. But more often than not, it takes, it can take 6 months to a year and a half, or in some cases, as I mentioned multiple times, with the 30 days for gubernatorial review, they will just let it sit there and languish if it's a reg that they don't want to see implemented. So I'd like to say these things were hard and fast. There are some immutable rules, and if an agency violates any of these, it gives you an opportunity to appeal the decision. And so we, of course, try and hold everyone's feet to the fire. The Administrative Process Act this year in particular has been so important because the ability for us to meet in person has been completely curtailed. And so many of us in the conservation community have been keeping a really close eye on how we make sure we're still doing what we're supposed to do in terms of public participation processes and the allowing the proper amount of time for public comment, and how do we make accommodations for public comment during this time. So it's the APA is, as you all have seen, incredibly exciting stuff, but it's so important, particularly in this year. And I know many of us have our issues with the APA. I'm not I definitely don't think it is the best thing we could have, but it's what we have, and you have to sort of dance with who you came with, and that's the Administrative Process Act. So yeah, again, sorry, that's a long way to answer your question, George, but I think that 120 days is not hard and fast. They can do it before.
So Jay, I'm going to answer Gina's question, and then I'll let you take Mark's. So Gina asked, what can a person who's new to water conservation do to get involved in Virginia? I got a great answer for that. She said, I believe agencies outside of the Bay Foundation may have been mentioned. Is there a quote best in certification or education to get involved? Hey, the grassroots staff in Virginia is about ready to kick off our first ever watershed-wide voices class. The first class is going to be October 6th. Graduates of the voices class, many of them go on to be clean water captains. We've got a bunch of them on the call today. They are our local eyes and ears. They are our wonderful clean water champions, and we can't do our advocacy work without them. So Gina, I'm happy to send you the link to Voices registration when that goes live. And I'll also give you just a couple other places where you can go that would be sort of more resources to sort of dig into how you can get involved. So Jay, if you want to take Mark's.
Sure, Mark. So when an agency issues their NOIRA, they'll usually lay out what they intend the process to look like. So when they issue that, they'll usually say, we're going to create a RAP, or if they determine they want to have a public hearing at that time, they'll include that in the NOIRA as well. And if they put it in the NOIRA, it has to happen. So if they say we're going to have a RAP and we're going to have a public hearing, then those things are coming to pass. They can make a decision after the fact, after the NOIRA, that they want to have a public comment period. And in fact, the APA lays out a process that that comments can force them to have a public comment period on a particular topic, not a public comment period, a public hearing. So if they receive over 25 comments that sort of question the content of a regulation, that will automatically trigger a public hearing on a proposed regulation. In terms of what the RAP, how that impacts the outcome, I feel, with technical advisory committees and RAP, sometimes these things are so technical. Right now, I'm serving on a RAP on the groundwater question for the Eastern Virginia groundwater area, and it's really in the weeds. And you've got well drillers in the room, and you have hydrologists in the room, and everyone's trying to come up with a way to put this into plain speak so we can get it into regulation. And I think the RAP is most effectual when it is that kind of highly technical and I think necessary. There are other times, I think, when you have work groups, RAPs or TACs, that end up steering outcomes. And so I think it cuts both ways. Sometimes they're absolutely necessary. Other times I wish there just wasn't a technical advisory committee so we could have a clean slate without preconceptions before a water control board. Because once a recommendation's been made by a technical group, it's really hard to maybe pull back to a more resource protective stance. And so, there's no hard and fast, yes, they're good, or no, they're bad. I think it's situationally specific. I do know that we often sort of bemoan that there aren't more conservation voices on these RAPs and TACs. We think it's really important that they should be better balanced, but a lot of times they're just absolutely necessary.
I'm going to read just so we've got it. Robin's question, she said, how can you tell if a bill is in process or the history of trying on something? For example, what is the history of banning plastic bags?
Yeah, so when there's the Virginia Legislative Services website, if there's something you want to know if it's a bill, you can usually figure it out there. The other thing is if you talk to a legislator and if their office doesn't tell you that the bill's already on the books, Legislative Services will. When every time legislators put in bills, it goes to a team of unsung heroes in Virginia. These are some of the attorneys that make up sort of the civil service backbone of our government. They're nonpartisan employees of the General Assembly who translate everything into legalese. They make sure that it works with the Virginia code. They make sure it's not duplicative, that it doesn't undercut other aspects of the code. So, I always say, and always encourage legislators to shoot for the moon. You throw all your ideas out there, they'll come tell you if it's in conflict with something else, but you don't self-censor because you don't want to worry about duplication. Briefly on plastic bags, we did actually see movement on that this year. So they did delegate authority to localities finally to adopt a tax on bags if they see fit. So go back to that Dillon rule page. This was the General Assembly saying, okay, we are giving you permission to do a very specific action on plastic bags. So that is out there now. It's maybe we could do more, but we have seen some movement.
I'll just add, Robin, I'll drop into the chat the General Assembly website, and you can always go in and in the search bar, you can just search plastic bags and it'll show you the histories of every time that bill has been brought up. You can see that Chap Peterson brought that bill up for like 4 years in a row, for instance. I mean, it's very easy to see the history of what's been introduced. And then you'll get a sense of, but that doesn't really address what I'm seeing. And so then you would go to your representative to say, I see this bill's been brought up, but it's not really fixing the problem that I have. So that's another way you might want to tackle it.
Okay, let me see here. Kit, your question about economic impact, what about environmental impact? So That's a great question, and it is if there's going to be an environmental impact, that assessment is not done when they consider when they start the creation of a regulation. If there is going to be an environmental impact, more than likely that there's going to be a permit involved. And if that's so, there will be a role for the regulatory agency, DEQ, but what happens when they create a regulation is they send it over to the Office of Budget and Planning, and they send back a suspected economic impact that is part of the record. But the APA is really clear that that enacting regulation that was set out in legislation should not be impacted by that economic statement. It's a factor that can be considered, but it can't be used to block a regulation effectively if law is already directed that it be created. But I share your sentiment. It'd be great if we did better environmental impact evaluations throughout the process. But for Virginia, if you catch a permit, that's where you're going to get to review. Let's see here.
So, Joe Valentine, I'm so sorry about that. Joe Valentine asked, at what point do lobbyists get involved, and can they bypass any of the rules? Think Delmarva Poultry.
Sure. There's no point they are not involved. That's the short answer. And I think a lot of people get frustrated with lobbyists' influence, but at the end of the day, it's not like they're not doing something evil or and conservation is doing something bad or something good. Lobbyists are it's their full-time job. So when you send an action alert during General Assembly and you call your legislator, those things are hugely important, but you have to also recognize that lobbyist is in their head all summer, all fall. They are in constant conversation. So it's their job. It can sometimes be frustrating, but they're almost always involved. And in Virginia, we are a very business-friendly state. So when we have RAPs and we have technical advisory committees, our lobbyists are very often on those committees as well, representing their industry group. So it is, again, as I said before, as one of our frustrations is that we have, we don't have proportional representation on a lot of these technical advisory committees. I happen to think that natural resources representatives sort of should have more seats, considering natural resources are held in common by every single citizen in the state. So we've got a pretty big constituency. So it would be nice if the representation on RAPs and tax reflected that.
Okay, so I don't know why I've got that feedback. Phil Irwin says, please suggest steps to end DST clock changes.
I'm sorry, Phil, I don't know what that is.
Yeah, I'll let him type a response. Richard just commented that lobbyists are educators. And I'll note that's true. And Jay and I are both registered lobbyists. And so we're educating on one perspective, and then industry is educating from their perspective. And the whole idea, I think, to have good, to have good legislation is that you are able to gather everybody's perspective so that you know that there is no, that there's, that we've got the best rules in place and no unintended consequences. All right, yeah, daylight savings time.
Yes, I will say, I personally like to say we are advocates and then there are lobbyists, because I think there should be a linguistic distinction that recognizes our resource gap. But so daylight savings time. I don't really have a lot of thoughts on this, but if you want to end daylight savings time, you'd need a bill. So you need to start, as I was saying earlier, now's the time of year you start talking to legislators if you want to get a bill in for pre-file. So reach out to your legislator, make your best pitch to end daylight savings time. And if you get them on board, get your bill in pre-file in early December. And I would very much enjoy that debate on the floor. So be very entertaining.
All right, guys, thank you so much. We're short for times now. We're right at 1 o'clock. So just thank you again for joining us, everyone. We will post the link to this, to the recording up on our website. And just again, thank you for your attention. We really appreciate it. And I will send the invite to Voices for those of you that are not Voices graduates with the link to the webinar. So Jay, thank you. It was great. I always learn something. and for everybody on the phone and the screen, thank you as well.
Thanks, everyone.